another unanimous ruling from the Supreme Court.
Breaking news from the State House, one of the big bills in front of the Senate.
The Supreme Court rejected Missouri's bid to revive its law.
The Supreme Court today handed down a major victory for gun control advocates.
This is big.
Recently, the Supreme Court issued an order denying a stay that would have protected the state of Missouri's Second Amendment Preservation Act.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
Declaring various federal gun restrictions unconstitutional in the state.
The Supreme Court just issued an emergency order that changes everything about gun rights in America. This wasn't a typical 5-4 split decision. It was 8-1, and the reason for that single dissent will shock you. What just happened affects 157 million Americans across 27 states, and it's creating a constitutional crisis that neither political party saw coming. The federal government is about to lose $1.7 billion in enforcement capability, and there's nothing they can do to stop it. This ruling centers on something called Second Amendment Preservation Acts, state laws that basically tell the federal government their gun regulations won't be enforced within state borders. Missouri started this movement, and now half the country is following their lead. The 8-1 vote stunned legal experts who expected another partisan split. Justice Ketanji Brown Jackson, appointed by Biden, sided with the conservative majority. Elena Kagan, who opposed expanding gun rights in previous cases, joined them. Even Chief Justice Roberts, known for avoiding controversial constitutional questions, fully endorsed this sweeping decision. But here's where it gets interesting. Justice Sotomayor was the lone dissenter, and not for the reason everyone assumes. She didn't dissent because she opposes gun rights. She dissented because she thought the court should have given states even more power to resist federal gun laws. The justice who consistently votes against expanding Second Amendment protections wanted Missouri to have stronger tools to block federal enforcement. This reveals something crucial about what's really happening here. This case transcends the typical gun rights debate. It's about the fundamental relationship between state and federal power, and that's why it garnered such overwhelming support from justices across the ideological spectrum.
But public safety concerns must be addressed in ways that are lawful.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act for the purpose of making a state a two-way sanctuary state.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
Give us transparency in how you're going to handle them, and if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fairer process for everyone.
The anti-commandeering doctrine, the principle that the federal government cannot force states to enforce federal laws, now has explicit Supreme Court backing in Second Amendment cases. This same doctrine protected sanctuary cities from enforcing immigration laws and allowed states to resist implementing parts of Obamacare. Now it's being weaponized for gun rights, and the implications are staggering. 27 states are positioned to immediately benefit from this ruling. 12 states already have fully enacted Second Amendment Preservation Acts. Missouri, Montana, Wyoming, Idaho, Arizona, Oklahoma, Kansas, Arkansas, Tennessee, Kentucky, West Virginia, and South Carolina. Another 8 states have legislation pending that passed at least one legislative chamber. 7 more have attorneys general who've issued opinions supporting the framework. The ATF employs roughly 5,000 people nationwide, but only about 20,500 are field agents who actually enforce gun laws. Those 20,500 agents are about to lose their most critical resource: cooperation from over 700,000 state and local police officers. When federal agents execute search warrants, they rely on local police for backup and scene security. When they investigate illegal firearms trafficking, they depend on tips from state law enforcement and access to state databases. In states with these preservation acts, that cooperation becomes illegal. State officers who assist federal gun enforcement face personal fines up to $50,000 under Missouri's law. The financial impact compounds the enforcement problem. The ATF's annual budget runs about $1.7 billion, with roughly $420 million going to grants and cooperative agreements with state and local agencies. These grants fund joint task forces, shared databases, and training programs. Missouri's law specifically prohibits accepting federal grants tied to gun law enforcement the state deems unconstitutional.
This is a case dealing with a state's Second Amendment Preservation Act, also known as the SAPA law.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
The government may not regulate individuals' possessions of weapons for self-defense.
Pretty based move here by the state of Missouri, saying no, we are not going to fund federal violations of the Second Amendment.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
If all 27 positioned states implement similar provisions, the ATF loses over $300 million in cooperative funding. But the real enforcement crisis comes from losing access to state databases. Every state maintains criminal records the ATF uses constantly. Concealed carry permits, state-level background checks, mental health adjudications, and protective order registries. These databases catch things federal systems miss, like recent protective orders or state mental health commitments not yet uploaded to federal databases. The numbers demonstrate the impact. Before Missouri's Preservation Act, the ATF traced approximately 4,100 crime-connected firearms in Missouri using combined federal and state databases. After implementation, that number dropped to 2,850, a 30% reduction. The ATF's National Tracing Center processes about 400,000 crime gun traces annually. If 27 states cut off database access, they could lose the ability to trace 200,000 firearms per year. Federal firearms prosecutions face an even more dramatic collapse. About 62% of federal gun prosecutions begin as state-level arrests that get adopted into federal court. Local police make the initial arrest, collect evidence, then refer cases to federal prosecutors when defendants qualify as prohibited persons under federal law. These preservation acts break this pipeline.
Major decision from the Supreme Court that could have larger implications on gun laws nationwide.
Is a massive deal. It directly goes after the ATF's tactics over the last 2 years.
They really don't know what to do with this one, which is always a good thing to see.
The ATF overreach has been stopped once again.
ATF is getting another lawsuit, this time by half of the country.
ATF and the government is going to fight this every step of the way. And sooner or later, it will land before the Supreme Court.
Basically, they kick the ATF in the teeth. They seem kind of punch drunk. They seem as though they got the bell rung pretty bad.
State officers can still make arrests under state weapons charges, but they cannot refer cases for federal adoption, coordinate with ATF agents, or testify in federal court about collected evidence. In Missouri's Western District Federal Court, firearms prosecutions dropped from 187 cases in 2022 to 103 cases in 2024, a 45% reduction. If all 27 states implement these laws, federal firearms prosecutions could plummet from 12,000 annually to under 7,000. The ATF's pistol brace rule exemplifies how federal gun regulations become unenforceable without state cooperation. This rule reclassified millions of braced pistols as short-barreled rifles requiring registration. The ATF estimated between 10 and 40 million pistol braces existed when they issued the rule. By the registration deadline, only 255,000 had been registered, a compliance rate between 0.6 and 2.5%.
The civil remedy here, or the lawsuits here that are going to be filed, are not going to be filed by the state of Missouri.
Not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule.
The Second Amendment protects the right to carry a gun in public for self-defense.
It triggers something in me that something has to be done.
State said we are going to take away all the funding that we are giving federal agencies when they come into our state and are trying to violate the rights of residents.
This case could reshape how far states can restrict your right to carry and where.
The ATF lacks manpower for door-to-door compliance checks. They rely on tips from local police and encounters during other law enforcement interactions. In Preservation Act states, local police cannot ask about federal registration status, report unregistered items to the ATF, or assist in executing related search warrants. The pistol brace rule effectively becomes unenforceable in half the country. This precedent extends far beyond guns, creating a framework both political parties will exploit and fear. Democratic states are already exploring applications. California's Attorney General expressed interest in using anti-commandeering principles to refuse cooperation with federal immigration enforcement. New York considers whether state agencies can deny criminal database access to ICE using Missouri's legal reasoning. Illinois explores whether state environmental agencies can decline helping EPA enforce regulations they oppose.
Your pistol brace is legal once again. Another court victory thanks to a Texas-Wisconsin tag team on this terrible rule.
Even if you are innocent,
your words can still be twisted and taken out of context.
Pistol brace is illegal, or declaring that your pistol brace equipped pistol is a short-barreled rifle, that's gone.
This rule reclassified large format handguns equipped with pistol stabilizing braces as short-barreled rifles.
The court has said in common use, that's off limits. Clearly, pistol braces are in common use.
Republican states see opportunities beyond firearms. Texas could refuse enforcing federal energy regulations on oil and gas production. Florida might decline assisting with offshore drilling restrictions. Multiple red states could unite in refusing cooperation on federal education mandates or healthcare regulations. The Supreme Court's 8-1 endorsement creates precedent applicable across all policy areas. For decades, the federal government assumed states would generally cooperate with federal law enforcement even when disagreeing with underlying policies. That assumption just died. Federal law enforcement faces a new reality where they must enforce their own laws with their own resources in non-cooperative states. The FBI, DEA, ATF, ICE, and other federal agencies combined employ about 37,000 field agents. State and local police number over 700,000. Remove that force multiplier and federal enforcement capacity shrinks dramatically. We're entering an era where the balance of power between Washington and the states fundamentally shifts. This decision may be remembered not for its impact on gun laws specifically, but for permanently altering American federalism.
The final rule on factoring criteria for stabilizing braces is no longer in effect.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
You had to register these pistols that were equipped with the pistol brace and to register them as short-barreled rifles.
Saying setting a higher threshold in an emergency could mean life or death.
When things sound really good for gun owners in court, that doesn't mean it's over.
The federal government's ability to implement national policies just became dependent on voluntary state cooperation, and in an increasingly polarized nation, that cooperation can no longer be assumed. The immediate impact falls on gun owners in those 27 states, who now operate under dramatically different legal frameworks than those in cooperating states. Federal gun laws still technically apply everywhere, but enforcement becomes virtually impossible without state assistance. This creates a patchwork system where your Second Amendment rights effectively depend on your zip code. For the ATF and federal prosecutors, this represents an existential crisis. Their entire enforcement model, built on state cooperation, just collapsed in half the country. They must now rebuild their approach from scratch, relying solely on federal resources in non-cooperative states. The constitutional implications ripple outward, affecting every area where federal and state law intersect. This 8-1 decision signals that the Supreme Court views state sovereignty as a fundamental principle transcending partisan politics. When justices from opposite ideological poles unite on expanding state power against federal overreach, it marks a pivotal moment in American constitutional history. That's it for today, folks. See you in the next video.